Hi everybody, my name is Miranda Dressler and I am the Associate Attorney at the Law Offices of Bridget and Mackay in Petaluma, California, and we practice in the areas of estate planning, administration, and elder law. And today I'm going to talk to you a little bit about the roles in an estate plan. So when you go and get your estate plan done, typically, the main document that you are probably thinking about getting is a trust. But there are other documents that come in a complete estate plan, and all of these documents are going to have multiple roles. You will fill most of those roles initially, and you'll also need to think about and appoint people for the other roles or to take over those roles after you're no longer able to act. So I'm going to talk a little bit about how that works. With the trust itself, when you create the trust, you are going to occupy the three main roles of a trust, which are you will likely be the trustor. That's the person who created the trust and transferred their assets into the trust. You will be most likely the trustee. The trustee is the manager of the assets in the trust. And you will also most likely be the beneficiary of the trust, meaning they're your assets, you benefit from the assets that you put into the trust. There's also a role in the trust that is called the successor trustee, and that is the person that you appoint to take over the role of trustee for you when you are no longer willing or able to be in that role yourself. Additional roles that come generally with or should come with an estate plan is going to be, number one, durable power of attorney agent. A power of attorney agent is someone you appoint, likely or often is the same person, but doesn't have to be, as you have named as the successor trustee of your trust. And that role really is to step in for you at incapacity to deal with any financial asset or item that is not in the trust. So, for example, paying bills, making sure your mortgage is paid, making sure your taxes are done properly. The other main document in an estate plan is going to be a healthcare directive, where you appoint a healthcare agent, a person to make healthcare decisions for you if you're no longer able to make them for yourself. And then finally, most well-done estate plans should have what's called a pour-over will. A pour-over will is really just there as a safety net in case any assets are accidentally left out of your trust. And in that, you'll need to name an executor. And the executor would really handle the administration of your estate if any asset needed to go through the probate process after you passed away. So you really need to think long and hard about who you're appointing in all of these roles and whether they're appropriate. Are they responsible? Is it someone that you trust to step in for you to manage these really important decisions that eventually will need to be made? So if you have any other questions or questions about any estate planning topic, you should consult an experienced estate planning attorney in your area. Thank you.